There are 7 legal principles of a contract. They are as follows. The first thing you must have to have a valid contract is competent parties. To be a competent party, the person must be of legal age and also of sound mind. The second thing we must have is an offer and acceptance, which means the parties must agree on the exact same terms. Keep in mind that the buyer always makes the offer first in a real estate transaction. So when the offer is made, the buyer is the offeror or the giver of the offer. Likewise, the seller receives the offer up front. So since the seller receives the offer, the seller is called the offeree, the receiver. Remember, OR is the giver or giver, if you will, and the EE ending word is always the receiver. If a seller decides to make a counteroffer back to the buyer, then now the seller is making the offer, so the seller becomes the offeror. Likewise, the counteroffer goes back to the buyer, so since the buyer is now receiving the offer, that makes the buyer the offeree. All offers also must be presented to the seller. If a listing agent happens to receive 2 different offers at the same time from 2 different buyers, then what order must the seller's agent present these into their own seller client? And the answer is the listing agent must present all offers together at the same time. This gives the seller the opportunity to either accept one of the 2 offers or reject, or possibly even counter on either one of the offers, but it is the seller's call to make. Keep in mind, even if it's a ridiculous offer, such as a buyer offers $10,000 and a couple of pigs for a piece of property, that would still have to be presented to the seller because all offers must be presented to the seller client. A third item to have a valid contract is consideration. Consideration is something of value or a promise to pay money. The offer itself, when a buyer offers to pay $200,000 for a piece of property, that offer itself is sufficient consideration for a contract. However, keep in mind, we do not have to have any earnest money to have a contract. Earnest money on a residential deal might be a couple of $1,000s that a buyer puts up with the offer to show sincerity. This is very good to have, and the more earnest money there is, the stronger the offer. However, we do not have to have it to have a contract. Contract law says there must be consideration, which is merely a promise to pay money. So do we have to have consideration to have a contract? Yes, we do. Do we have to have earnest money to have a contract? No, we don't. The fourth item is a lawful purpose. Every contract must be for a lawful purpose. The fifth item deals with writing. Does a contract for real estate have to be in writing? The answer is not necessarily, but normally speaking, real estate contracts have to be in writing to be enforceable in court due to a body of law called the Statute of Frauds. So could we have a couple of farmers on a real estate deal shake hands and show up at closing and it is verbal the entire time? Yes, we could. And if they close, that would be a valid contract. However, if one of the farmers backs out before closing, could the other farmer sue in court to force completion? The answer is no. Because the Statute of Frauds says that if it's a contract for real estate, it must be in writing to be enforceable. Not necessarily valid, but to be enforceable in court. The sixth item deals with we must have signatures of the parties involved to have a valid contract. And finally, the seventh element is we must have an adequate description of the real estate. This is typically a legal description, but an adequate description is just fine. Once a contract is signed, let's talk about the legal effects of that contract. There are 4 ways we have of classifying these contracts. One is a valid and enforceable contract. That simply means it has all the essential elements of a contract and it's in writing, which makes it enforceable. That's what we want all the time. A second way we can classify a contract is a void contract, which means it has no legal effect whatsoever. A couple of examples of a void contract would be a contract for an illegal activity or someone who signs a contract who is not of sound mind. Those contracts would be classified as void and have no legal effect whatsoever. A third type is called a voidable contract, which means we have most all of the essential elements of a contract, but something is not quite right. What makes it not quite right makes it capable of becoming void. Some examples would be a contract signed by a minor. A minor is not of legal age. So if a minor signs a contract, the minor can void the contract up until the minor becomes of legal age. Once the person becomes of legal age, the person must then make up their mind whether to ratify and accept the contract or to void out the agreement. Another example of a voidable contract is someone who signs a contract who is intoxicated. That would be a voidable contract. Another type would be misrepresentation. There are two types of misrepresentation that would be considered voidable contracts. One is called innocent misrepresentation. That's a situation where a licensee fails to disclose something that was in the multiple listing service information, for example, and just overlooked it. Another type of misrepresentation is called fraudulent misrepresentation. Fraudulent misrepresentation is when a licensee flat out lies simply to close on a transaction and to make some money. Either one of these types of misrepresentation, however, would be a voidable contract. So, for example, if a seller told a buyer that the property was zoned commercial, and after closing the buyer found out that it was actually zoned residential, that the seller had lied, then the buyer would be able to go back and try to void out the agreement due to the misrepresentation. The only one that can void out the agreement in these voidable contracts is the injured party. The injured party is always the minor or the person who was intoxicated or the person who was misrepresented. A fourth area we have is called an unenforceable contract, which will be like an oral contract for real estate. The statute of frauds once again says that contracts for real estate, if you want to enforce them, must be in writing. Once parties agree to a contract, let's talk about what happens ultimately down the road, whether we close or we make changes in the contracts. One type of change in a contract can be a breach of contract. Breach means break or tear. That's if one of the parties does not perform according to the original agreement. If one of the parties backs out, what is the other party's remedy? One thing that the party can do is file for a specific performance lawsuit, and that is court action to force completion. So if a buyer refuses to close, the seller might be able to sue the buyer to complete the deal as was originally agreed to. A second item available to either party is to rescind the agreement. Rescinding the agreement means both parties go back to square one. We pretend it never happened. This is a situation where if a buyer backs out, for example, the seller can say, let's just rescind the agreement. We'll both sign off and pretend this never happened, and the seller will then sell to a different buyer. A second change in a contract would be an assignment of an agreement. Assign means transfer. So if a buyer has a signed contract to buy a piece of property, can that buyer transfer his or her rights to another buyer and let someone else close on the agreement and close on the transaction? The answer is yes, this is allowed unless there's a clause in the original contract that forbids the assignment. Otherwise, contracts are freely assignable or transferable to other parties. A third change is called a novation. Novation means new. A new contract takes place of an old contract. That would be a situation where a borrower goes in to refinance a loan from an 8% interest rate down to a 5% interest rate. We call this a refinance. A refinance is a type of novation because a new loan contract takes the place of the old loan contract. The fourth way is called an addendum or an amendment. What happens when a seller and buyer can't close on time, and we need to extend the closing date by 1 week? Then we would need both parties to sign what is called an addendum, addend means add, or an amendment, amend actually means change. Either term works for our exam. Somehow the addendum or amendment will change or modify the original agreement. Option contracts are a situation in which a seller says to a buyer, I will sell you my property, but the buyer says, maybe I will buy the property. So it is a one-way promise. The parties involved we call the optionor and the optionee. The optionor is the giver, again giver of the option, and that's going to be typically your seller. The optionee is going to be the receiver of the option, and that is going to be your possible buyer. To have an option agreement, we need two things right up front. We have to have a definite sale price, and we have to have a definite time frame. So a seller might say to a buyer, I will sell you my property for $500,000 for the next 1 year. And the buyer says, okay, let me think about that for 1 year. So we have a time frame up front as well as a definite price. Therefore, this would be a valid option agreement. Normally, in an option contract, a seller will want some type of option money or consideration for allowing the buyer to think about buying the property. In our example, it was for 1 year. So if we have a $500,000 sale price, let's assume that the seller would require the buyer to put up 10% option money in order to sign the option agreement. That would be $50,000. The $50,000 stays with the seller regardless of whether or not the buyer ever exercises the option. That's the seller's consideration for letting the buyer think about it for 1 year. The buyer does not have to buy because, once again, it's the buyer's option. But if the buyer does not buy the property within that 1 year time frame, the buyer does not get the option money back. That stays with the seller. When a seller and buyer agree to sell and buy a piece of real estate, they will typically enter into what is called an offer to purchase contract, or we commonly call these sales contracts. These contracts are bilateral because it is a two-way promise. Many times a buyer will include what is called a mortgage or financing contingency clause that says the buyer will only close on the property if the buyer is able to obtain financing. This is the way that a buyer can sign a contract and yet have the ability to back out if the buyer does not qualify for the loan. If the buyer does not qualify for the loan and the deal falls apart, the buyer also should receive any earnest money back that was part of this real estate deal because of the financing contingency clause. Another typical clause that gives the buyer the ability to back out of a contract before closing is an inspection clause, or it's also called a due diligence clause. This gives buyers the right to do inspections, and if something is found to be wrong with the property, such as roof leaks, basement leaks, environmental hazards, those type of items, then a buyer may try to go ahead and back out of the contract and be released. That is the purpose of the inspection or due diligence clause. Typically with a sales contract, the buyer will put up some earnest money with the initial offer to show sincerity. On a residential transaction, it might be a few $1,000s on a house purchase. This earnest money needs to be kept somewhere between the signing of the contract and the closing. The earnest money is kept in what is called an escrow or a trust account. Either term works. The brokerage companies can hold these. Many times title companies can hold the earnest money in their own escrow account as well. If a brokerage company has their own escrow account for holding earnest money, the broker cannot commingle funds. Commingle means to mix with your personal or business funds. Also, a brokerage company cannot just flat out steal the money out of the escrow account and take off with the money. That would be called conversion. Conversion is converting someone else's money to your money. When it comes to preparing legal documents for a real estate transaction, only attorneys can prepare or draft legal documents. Real estate licensees cannot do this. Real estate licensees can take pre-printed contracts that have been approved by attorneys and fill in blank spaces, such as sale price and closing date, but only attorneys can prepare legal documents. Let's discuss legal ways of giving a property description. First off, an address is not a legal description. An address is what a property is commonly called, and that's established by the post office. But let's discuss 3 ways of giving a legal description. Number 1 is called a meets and bounds description, which gives a physical description of the property. These are typically older or used in rural areas. This is where the description would say go to the well, then 300 feet west to the stake, and then 200 feet to the tree. It uses physical objects to describe the land. One key thing to remember with the meets and bounds description is that the description must begin and end at what is called the point of beginning. The very last line of every meets and bounds description will say, and go back to the point of beginning. You have to enclose your description. A second way of giving a legal description is called the rectangular or government survey system. This is what was set up years ago by Thomas Jefferson in our country, and it pretty much covers the entire country. Thomas Jefferson drew nice straight lines, vertical and horizontal, called principal meridians run north and south, and principal baselines run east and west, in an effort to try and describe all of the land in our country. With the rectangular survey system, we need to know what a section of ground is. A section of ground is 1 mile on all sides, which means it is 1 mile square. To find the area of something, we take the length times the width. So if we also take 1 mile times 1 mile, that means a section of ground contains 1 square mile. So 1 mile square and 1 square mile is the exact same thing. Please remember, every section of ground in this rectangular survey system contains 640 acres. You must also know for our exam that every acre of ground contains 43,560 square feet. A third way of giving a legal description is called a lot and block description, which is used in cities with new subdivisions. The lot and block description is recorded on a plat map. A plat map shows all of the lot numbers and block numbers in a particular subdivision, and this records the legal descriptions on the public record. A lot and block description will simply list the lot number, the block number, the subdivision, the county, and the state. So a description might be Lot 2, Block 4, Oak Hills Estate, Johnson County, Kansas. That's all, and that would be our legal description. Front footage of a property is the straight feet along the street line, or in essence the width of your property. And to find the square footage, we always take the length times the width. Many times, ownership of real estate can be done by organizations. Let's talk about a few of them today. One type is called a corporation. If a corporation purchases real estate, the corporation takes title in severalty. Severalty again means one only. It comes from the root word sever, which means to cut everybody else off and buy all by yourself. Another way to purchase property with an organization is through a partnership. We have to contrast a general partnership versus a limited partnership. A general partnership is where two parties, let's say Bill and Sue, get together and decide to invest in real estate. As general partners, they have unlimited liability. They also will make the decisions on how to invest and how the partnership is to be run. Sometimes Bill and Sue might bring on what we call limited partners who would invest, say, $5,000 apiece in the general partnership. The limited partners who invest $5,000 have limited liability, which means all they could lose would be $5,000. The general partners, keep in mind, have unlimited liability. And finally, let's discuss a real estate investment trust, or a REIT. This is basically a huge mutual fund for investing in real estate. People who sell mortgage securities and stocks and bonds and mutual funds, those folks have to have a securities license. Just like real estate licensees have to have a real estate license, people who sell securities, again stocks and bonds and mortgage securities, have to have a securities license in order to do that kind of work. The Securities and Exchange Commission, or the SEC, is a government organization that supervises all of the sale of securities every day in our country. When it comes to fair housing laws, there are 3 fair housing laws we need to know for our exam. The first one is the Civil Rights Act of 1866, which was passed after the Civil War. This law says that we cannot discriminate based on race only in the sale of real estate. The second act is the Civil Rights Act of 1968. This applies to residential transactions only in real estate. We now have 7 protected classes, whereas the 1866 Act only prohibited against racial discrimination. The 1968 Act adds the following 7 protected classes: race, color, religion, national origin, sex, meaning gender, and also in 1988 we added the handicap, that's a mental or physical handicap, as well as familial status, which means we have a family with children under the age of 18. One cannot refuse to sell or rent to someone based upon, for example, their race or religion or national origin. Also, one cannot change terms for people based upon their protected class. There are 3 big areas to focus on for our exam. One is called blockbusting. Blockbusting deals with the sellers. It basically prohibits real estate licensees from encouraging sellers to sell their property by saying persons of a protected class are moving into the neighborhood. In essence, the licensee is trying to bust up the block. This is illegal under fair housing laws, the fair housing law specifically of 1968. Also, we have steering as a very important component. Steering deals with the buyers. Steering is directing persons towards a certain area of town based upon their race or religion or national origin. That is also against the law. The 1968 Act also said that redlining is illegal. Redlining deals with lenders and insurance companies who refuse to make loans or refuse to issue insurance policies on property because the company does not like the type of people who live in that particular area of town. That is also illegal. Redlining gets its name from lenders years ago using a red marker on a map and refusing to make loans in certain areas because of the type of people who lived in that area. Again, that is now illegal under the 1968 Civil Rights Act. There are a couple of exemptions to the fair housing laws we do need to discuss. The first one is an owner selling their own single-family home themselves. If they do not use a real estate agent, this person is simply a for sale by owner, and also the person does not discriminate in advertising. That person would be exempt from the fair housing laws. A second exemption would be for religious organizations who can discriminate based on religion as long as they are a not-for-profit or a non-commercial entity. Even though we have a couple of exemptions to the fair housing laws, we have a court case in 1968 called Jones v. Mayer that basically said even if a person does fall under one of these exemptions to the fair housing laws, that person can never discriminate based on race under any circumstances whatsoever. So if we have a person who falls under the exemption, maybe a for sale by owner, that person may be able to discriminate based upon national origin or maybe based upon sex, something like that. But that person could never discriminate based on race under any circumstances whatsoever. Let's discuss the Fair Housing Amendments Act of 1988, which added two additional protected classes. The first one is a handicap. A handicap, by definition under this law, is a mental or physical handicap. What is not a handicap? Congress specifically said that a person who is currently addicted to illegal substances, such as cocaine, that person does not qualify as a handicap under this law. A person cannot change terms for someone based upon their handicap. Also, a handicapped tenant, for example, can modify the space at their own expense to make living conditions easier. If we have multifamily units, which are 4 or more, that were built after March 13, 1991, they all must now be accessible to those with a handicap. If there's an elevator, all of the units must be accessible. If there is no elevator, then just the ground floor units only must be accessible. The second item under the 1988 Act is familial status, which means we have a family with children under the age of 18. Prior to this, we used to have apartment complexes, for example, that would be for adults only. You don't see those anymore because people with children under the age of 18 are now a protected class. The one exception to that would be retirement communities. If everyone is 62 years of age or older, then those particular communities can say no children. Keep in mind, age is not covered under our fair housing laws. So if a person wants to refuse to rent to someone because they are 19 years old or 70 years old, that actually is allowed. Keep in mind that's different from what we're talking about here with the retirement home community exemption. If someone feels that they have been discriminated against, that person must file a complaint with HUD, the Department of Housing and Urban Development, within 1 year. And finally, residential real estate offices must have a fair housing poster displayed to be in compliance with the fair housing laws. Residential licensees do not have to use the fair housing logo system in all advertising, which is a house with an equal sign inside of it. Although HUD does encourage this to be done, the fair housing logo in advertising is not required. The fair housing poster, however, is required.